Tax day is less than a week away, and the American Civil Liberties Union is looking into whether the IRS is reading more than just your tax returns. ACLU workers filed a Freedom of Information request asking whether the IRS is reading private emails without a warrant. If true, that could be a violation of the Fourth Amendment of the Constitution, a guarantee against unreasonable searches. There are many layers to this story. The Fox Sports chief correspondent Jonathan Hunt's been looking into it all day. At the very least, the IRS rules are unclear.
Yeah, this is a lot more complicated than we thought it was when we first looked at the headlines this morning, Shep. Here's something from the Internal Revenue Manual, Part 9, written in 2009. Quote, the government may obtain the contents of an electronic communication that has been in storage for more than 180 days using a search warrant, a court order, or a grand jury subpoena or administrative summons. Now, the ACLU attorney who first wrote this, Nathan Wessler, believes that sentence should end at search warrant, but it goes on. The problem here is the administrative summons, according to the ACLU. That essentially means, Shep, that two IRS agents can talk to each other, decide these emails are relevant, and then go to the internet service provider and say, we need those emails. It's just them deciding that. That's the problem here, according to them, that they don't have to bring in the courts. On the other hand, the internet service providers in most cases would say they will not hand over that information without a search warrant. So it's not black and white, but it's precisely the areas of grey that are of concern here.
What's the IRS saying?
IRS isn't saying anything right now. We reached out to IRS officials. They said they may send a statement later in the day about this, but we have heard nothing as yet. The ACLU, meantime, has put out a statement paraphrasing the work of the attorney, Nathan Wessler, saying, quote, the IRS should tell the public whether it always gets a warrant to access email and other private communications in the course of criminal investigations. And if the agency does not get a warrant, it should change its policy to always require one. So in the view of the ACLU, it is in fact black and white. Tell us whether you always get a search warrant or not, as simple as that.
All right, Jonathan, let's bring in the judge now. Fox News senior judicial analyst Judge Andrew Napolitano is here. I'm a little confused.
Well, Jonathan has accurately described this. First, it is very complex. Now, he and I both read the regulations this afternoon. It's about 3.5 inches thick, single-spaced. So you have to sort of zero in on what you're looking for. So a couple of basics. The IRS does not have the time or the inclination willy-nilly to start reading people's emails. We're talking about cases where the IRS believes there's criminal fraud involved. So these are criminal investigations. A very, very, very tiny percentage of taxpayers may be involved in being investigated for crimes by the IRS. What does the IRS do in order to get information to build a case against these taxpayers? It's supposed to use a search warrant. But according to these regulations, there are circumstances under which it can go to the service provider, the computer company, and say, these emails have been here for 180 days. They've been opened. They haven't been deleted. Don't you think that this person doesn't care if anybody reads them, that they wouldn't leave them there for 180 days where your employees can read them? So we're going to give you a subpoena. I'm authorizing my IRS colleague to take these emails from you. Now, the person who put the emails there, received it, opened it, and didn't delete it, may never know that these emails have been taken by the IRS because they may not form the basis of a criminal prosecution. They may never even be used against this person, and they'll just go on with their merry life. The only way this comes into play is if the IRS wants to use in a court of law these emails. Then the IRS will have to explain to a judge how they got it, and then the judge will say, well, how is that consistent with the Fourth Amendment? You didn't come to me and ask for a search warrant. You just went and took it.
There's so many more instances of elements of the government or authority figures in this country.
Well,
delving into our stuff.
Yes. Now,
stay out of our stuff.
We learned.
It's not your stuff. It's our stuff.
We learned earlier this week that the IRS is using the social media. That's lawful. If I put something on my social media for anybody to look at who logs on to that, the IRS can look at it.
That's like
that's
saying
a billboard.
It out loud to an IRS agent.
Exactly, exactly. So that's actually a prudent thing for the IRS to do. But what the ACLU, in my view, quite properly wants to know is, are you following your own regulations which tell you how to get around the Fourth Amendment, or are you following the Fourth Amendment? And the IRS, as Jonathan indicated, has not yet answered that question.
But hopefully they will.
Yes.
You know what happens next, though? Anybody they suspect of cheating, they just drone them. There are plenty of drones.
I don't think the IRS owns the drones yet, but their colleagues in Homeland Security do.
Yet being the operative word.
Yeah, if they want drones, they'll get. Everybody should have a drone.
Let's not go there.
It's coming, Judge. Thank you.
You're welcome, my friend.